Factors such as a challenging economic climate, increased employer costs, and employment law reform are forcing many employers to evaluate their workforces and ensure that they are fit for purpose as we move towards a landscape where legal risk is increasingly at the forefront of employer considerations. I'm Jo Henderson, a partner in the employment team at Myerson Solicitors. In this video, I'll be looking at redundancy and reorganisation from an employer's perspective. For many organisations, restructuring is not simply about reducing headcount. It can involve changing roles, reorganising teams, relocating functions, introducing new ways of working, or responding to commercial pressures. While these changes may be necessary, to avoid disputes and employment tribunal claims, employers need to ensure that any redundancy exercise is carefully planned, legally compliant, and properly documented. The first question is whether there is a genuine redundancy situation. In legal terms, redundancy arises only where a business or place of work closes, or where the requirement for employees to carry out a particular kind of work has ceased or diminished. Establishing a genuine redundancy reason is essential, because without it, there may be no legally fair reason for dismissal, resulting in a claim of unfair dismissal. From the 1st of January 2027, such claims can be brought by employees who have just 6 months' service, and these claims will be uncapped in value. A genuine redundancy situation is only the starting point. Employers must also be able to demonstrate that treating redundancy as a reason for dismissal is reasonable in all of the circumstances. Acting reasonably involves identifying fair and objective selection criteria and applying those criteria in a reasonable way in order to select which employees will be personally affected by the redundancy situation. Employers must avoid using potentially discriminatory or unfair subjective criteria and must be able to substantiate scoring against the criteria applied. Acting as a reasonable employer also involves proper and proactive consideration of alternatives to dismissal, including suitable alternative roles for affected employees, and also a meaningful consultation process with employees about the proposed redundancy termination and its impact. Where larger scale changes are proposed, employer obligations are more complex and onerous. Where an employer proposes 20 or more redundancies at one establishment within a 90-day period, specific collective consultation obligations also apply, requiring consultation over minimum periods. Legal requirements involve appointing employee representatives, providing specific written information about the employer's proposals, and meaningful collective consultation with recognised trade unions or elected representatives. This is a complex area of law which is subject to upcoming changes in relation to the thresholds triggering the requirement to consult. Failure to comply may result in awards of up to 180 days uncapped gross pay per affected employee. Collective consultation obligations are not limited to traditional redundancy exercises. The collective consultation requirements are also triggered in fire and rehire situations, which employers may need to engage in as a last resort to achieve changes to terms and conditions of employment. Employers are required to comply with yet further obligations in these circumstances, and further legal reform will be enforced from January 2027. Employers must take careful legal advice if this is the type of reorganisation that is envisaged. Careful planning, clear communication, and a well-thought-out strategy are often the difference between a successful reorganisation or an outcome involving individual or collective disputes, damage to employee relations and reputation. Employers who understand the legal framework and engage with employees in a meaningful way are better placed to achieve their objectives while minimising legal risks. At Myerson Solicitors, our specialist employment team advises employers on individual redundancy situations through to large-scale reorganisations, collective consultation exercises, changes to terms and conditions, and trade union negotiations. If you are considering a redundancy programme or organisational restructure, get in touch with our team by calling 0161 941 4000 or visit our website to find out more at www.myerson.co.uk.